Okay, we're back and we're going to continue on with our discussion around 3 ways to get a mediator.
Yep.
And I'm Robert.
And I'm Rick.
And we will continue on with part two. And part two of this series is self-selection of a mediator.
Yes.
Okay. In this segment, we're going to talk about how you would go about doing that, how you would find a mediator, and what's some of the criteria that you would look for. So you ready to go with that?
I'm ready. How about you?
Let's do it.
All right. How do you get a mediator if you're going to self-select?
Well, you could go to the phone book, but we don't have phone books too much today now. So you could go on the internet and
Google?
You could do that too.
Okay.
So there are many ways to find mediator.
Mm-hmm.
Yeah, you can go on the internet and you can Google mediators and it'll pull up lots of things and ways to go about that. But one thing you want to make sure of is that when you do select a mediator here in the state of Georgia, you might want it to be one that's on the state mediators register and someone who's been trained and met all the requirements for the state of Georgia. So any other basic things other than that?
Yeah. What is there a risk of people being out there claiming to be a mediator that aren't trained?
That's an interesting way that you put that, because there are people who are trained mediators and they are very well trained and qualified, but they might not be on the GODR's mediators list, the
Right.
state list, because if you're not going to do court mediation, you don't need to be on that list.
True.
So finding a mediator from the list is one place to look. Finding a mediator online is another way to do it. And just, well, you said, you Google mediator and see what you get, and what is your case about?
Yeah.
What type of mediator do you want? If your case is a personal issue,
Mm-hmm.
then you would look for someone trained in maybe just general or civil mediation.
Right.
If your case involves divorce, then you would want a mediator who is trained and experienced in divorce mediation. So depending on what your issues are, what your complaint is, will determine the mediator that you will select.
Okay. So they can be found.
Yes.
Okay.
Yes. It's not hard to find a mediator.
Well, and also they can always call the center, and we can help provide you with a mediator for just about any case that you have.
So yeah, that's another way, and that's what we want them to do, really.
Can I give them the number?
What, the 404 number?
Yeah.
Okay, why
All
don't
right.
you do that? 404?
I wanted 404-991-0072, and we'll be glad to hook you up with a very good mediator.
Okay. So, and we do have a tremendous list of mediators.
Yes.
So,
Yeah.
including us.
Yeah.
So, okay. We'll talk about the finding a mediator, and in the first part of the series, we went over a lot about the mediator and qualifications and everything,
Yep.
all of those things. So I don't want to go through all of that again, because we've done that. But you have mediators who are trained mediators, and that's their background. Their background is really varied.
Yes.
Then you have attorneys who are mediators. Okay.
Yes.
So you can find a mediator going through the attorney's roster, if you will,
True.
and find the mediators there. So you have attorney-trained mediators and you have non-attorney mediators. And again, the selection of who and what you want, that's entirely up to you.
Right.
Okay.
Right.
So.
And in some cases, you may want an attorney who's trained as a mediator to do your case, because they've got more background in the legal side of things.
What's an example of when it might be more beneficial to have an attorney-trained mediator?
Even though the attorney cannot give advice, right? As an attorney, the mediator can't give advice, but say something like special education, right? There's certain rules around IDEA, which are the laws governing special education. You want a mediator who at least knows the language,
Right.
the terminology, so that they can ask good questions and they know the direction to send things.
Mm-hmm. So the same thing could apply if it's a workplace dispute.
Right.
Someone that's familiar with the workplace and some of the rules and regulations of the workplace and the union rules and regulations.
Yes.
Which can become very important in facilitating the mediation.
Yep.
Okay.
Well, besides the mediator, just like we talked about before, the context is different. Where in court mandated, it's driven predominantly by what's happening in the courtroom and what the judge might say. In a self-selected one, there are no time limitations at all. You can actually have multiple sessions. In fact, you can break between sessions. In some cases, it's preferable to be able to have multiple sessions, like divorce. In most of my divorce cases, we don't get it all done in one day. And sometimes the emotional drain is too much, so hour-and-a-half sessions, and we come back multiple times to address issues. You can take the time to go get advice, do some research, run it by your friends or your people that you trust. Here's what I'm thinking about doing. Do you think this is a good idea? You can go do all that. You can go talk to a financial advisor or talk to a tax person. Come back to the next session.
Yeah. So all of the things that, or some of the things that we talked about in court-mandated mediation that you were restricted from doing,
Yep.
in private mediation, you have freedom to do all of those things plus.
Yes. Lot less pressure as far as time is concerned. We're not running on a clock that says this is going to be done today.
Mm-hmm.
Confidentiality is even stronger in private mediation. If you take something to court, as soon as it gets in front of a judge, confidentiality is off. Now, in your court-mandated mediation, what happens in the room is confidential. But this way, you could have a case, you could have a dispute with somebody, and maybe it's not all that legal. Maybe it's, a relative that you have a dispute with. You don't want to sue them. And certainly you don't want it to become public. You can self-select, decide that you're going to go to mediation, pick your own mediator, and then the confidentiality will be, nobody need know about that.
Well, who's going to ensure that the confidentiality holds up?
Well, the parties typically, if they want this sort of thing, like the relatives, they don't want everybody to know about it, they're going to keep it. And the mediator actually has federal and state laws that protects the mediator, that they do not have to divulge information. So, and confidentiality is forever. There's no time limitation. It doesn't end.
Are there times during the mediation where confidentiality would not apply?
There are exceptions to confidentiality in different types of cases. But in Georgia, to be on the court roster, which typically is violence, any violence that breaks out in a mediation, threats of violence, harm to a third party or to self, those are exceptions, and we are obligated to report those things if they come up in the mediation.
Okay.
But other than that, everything else, nothing gets shared.
Okay, so if the parties share something with the mediator, and they say, but I don't want you to share this with the other party,
Stays confidential.
then you're obligated to keep that to yourself.
Never come up, yes.
Okay.
The other thing with the context that's different from court is the court's free to you. And when you show up in the court and the judge assigns a mediator to you, it's court mandated, it's free. And you, like you said, you get whatever the judge picks. This, you pay for this service, but then all of those other benefits. There's going to be some cost to you, and depending upon the type of case or the experience of the mediator, you've got all those benefits, and you're paying the mediator directly or the center directly. in those cases. So depending upon how, by the session, by the case, it could vary, but there will be some cost associated with it.
So if I hire a mediator, then private mediation,
Yep.
I should expect to have to pay for.
And you
pay
can
for that.
you can shop for different prices, and sometimes it's an hourly rate, sometimes it's just a flat rate.
Okay, and the mediators pretty much set their own costs.
Right,
their price.
typically.
Yeah.
Yeah.
Okay. Now the other thing about the private mediation. In the court-mandated mediation, you talked about evidence, rules of evidence.
Right.
How does that apply in private
Yes,
mediation?
and just to review what we said in the court mandated one, there's rules of evidence in the court that you have to abide by. All of those are out the window. You don't have to follow rules of evidence. Anything counts. Any stories, hearsay, videos, I mean, you want to bring it and share it with the mediator, share it with the other party. It's acceptable, it's admissible. The goal of evidence in mediation is to convince the other party. The other party's the decision maker. The two decision makers are the two parties, not the mediator, and there's no judge here. So evidence plays a very different role.
So the evidence in this case is your storytelling.
Yes.
And how well you tell your story.
Yep.
And how well the other party tells their story.
Yep.
And hopefully it's done well enough so that a decision can be made.
That they can find something to
They
agree
can
on.
come to an agreement.
Yep.
And walk away feeling good about themselves. The again, one of the differences here is that if you want advice, we can call a break.
Yes.
And you can seek advice, or financial, legal, whatever it is that you might need. You can call a timeout, and you can do that. So that's another big plus about the private mediation. Here, the same rules as far as coercion apply. The mediator can't and shouldn't do that.
No coercion.
Okay.
No pressure whatsoever.
So this is more, in a sense, more of a voluntary process than the court-mandated
Yes.
mediation. Okay. So if if someone is interested in private mediation, what's one of the steps that they can take to reach us, maybe?
Well, the first step, I mean, the very first step you should do is call the center. Call us, 404-991-0072.
And we can help you in the process of selecting a mediator.
Right. And if you're just wondering whether, is this worthy, I mean, call, you'll get a chance to talk to one of our case managers and determine whether this is the route you want to go, as opposed to filing a lawsuit in court.
Yeah. And that's an open call.
Yes.
So
Yes.
again, the number 404-991-0072.
Yep.
And
Well, that takes care of the second part of our series. We'll take a break and come back to our third section, and that is attorney recommended mediators.
10 years to learn the business. 10 years to make a name. 1 year on your own. It takes time to build a small business, but only 60 days to transform it with email marketing from Constant Contact. Sign up with Constant Contact and get 60 days of free email marketing to generate referrals, connect with clients, and build the business you've always wanted. Constant Contact. Start your 60-day free trial today.
What happens when soldiers come home? Brene Foundation offers hero support to ensure that our heroes abroad can continue to be heroes at home. We link veterans with organizations who are dedicated to guiding the transition from military hero to civilian hero. If you want to find out how you can support our troops at home, please contact the Brene Foundation or visit brene.com.
Hi, everybody. Welcome back from the break. We want to thank our sponsors again. We're in part 3 of the 3-part series. The title was 3 Ways to Get a Mediator. We've already looked at part 1, which was court-mandated mediation, when the judge assigns a mediator to you or the court assigns a mediator to you. Second, we did, right before the break, self-selected mediator, where you get to pick the mediator, and there's far more flexibility and freedom in that process in terms of what's available to you. The third one we want to talk about is an attorney recommended. Your attorney recommends a mediator for you, or usually what happens, you got a lawsuit, you got a plaintiff and a defendant, and what ends up happening is each attorney selects or recommends a mediator. It's got to be somebody that both of them like, typically. And so that...
Why would the attorney recommend a mediator? Wouldn't they just want to handle it themselves?
Well, sometimes, in some cases, depending upon the type of case, the court has mandated that they have to go to mediation. They're not going to show up in court and get a mediator, but you have to go to mediation before you show up. In that case, they usually have a list of mediators that they like and that they pick, people that have done good jobs for them in the past.
Okay.
So, and in some other cases, a lot of good attorneys out there recognize that mediation is going to be a better route because the cost side of it could be huge. You know, if we go through discovery and we go through all those processes, this is going to cost you a ton of money. Mediation could get you out of here faster and cheaper, so they sometimes recommend mediation.
Okay, so that would be one of the reasons for the attorney to recommend mediation.
Right.
Okay. So would the attorney, could they also act as the mediator?
No. Yeah, that mediator sitting in that chair, even if they're an attorney, can't act as an attorney sitting in that chair. As soon as they put that mediator hat on, you can't be whatever your other profession was. You can't be a counselor, you can't be an attorney, you can't be anything but a mediator. So it's a conflict of interest because as their attorney, they are an advocate for their client. Mediators do not advocate.
But an attorney can be a mediator.
Yes, an attorney can be a mediator.
So as an attorney, I can be a mediator, but I can't mediate a case that I'm handling as an attorney.
Can't mediate your own case.
Bummer.
So that's why the other attorney's not going to let you do it either. They're not going to trust you in that situation. So they usually find somebody that they both agree upon, that they like. And oftentimes, not every time, but oftentimes that mediator will in fact be another attorney. They're not acting as an attorney in that chair, but they have legal background, they have knowledge of the law. And that's one of the expectations of the attorneys selecting that mediator, is that they will expect the mediator to give some sort of idea about the case to their client.
So they on some level, they are giving advice, if you will.
Well, they would say no. They're not. But the reason I'm pointing this out, and for you as a consumer, if you are choosing, if your attorney has recommended mediation for you and you go to mediation, I want you to be aware that some of the things that our attorneys expect may not be the best for you and may not be the best practice as far as mediation is concerned.
But the mediator is still going to be trained.
Yes.
It's going to be a mediator that's trained and has met all the requirements of GODR.
Right.
So we're going to get the same quality of mediator here as we did in court mandated and self-selection.
Well, they're going to be trained. But let's put it this way. They can have the same skills, but let's talk about it in terms of a different style. They have a style that's more case evaluative, and the attorneys expect them to be case evaluators. So sometimes what I'll hear, attorneys want the mediator to say in caucus, say to their client, you know, I know the judge that you're going in front of, and this is just not going to fly in front of the judge. Technically, mediators aren't supposed to do that, but sometimes attorney
The attorneys
mediators
can do
expect the mediator to do that.
Okay, the attorney expects the mediator expects the attorney to do that.
Well, yeah, that's the way. The attorneys in the room, the representatives, the advocates
Okay.
are the ones who are supposed to be doing that. But sometimes it'll be, you know, I got a really tough client, or I need you to do some reality testing for my client, and they'll pick someone who knows the law, so they sound more credible talking to their client. The mediator sounds more credible talking to their client about what will and will not work.
Okay.
But the danger is we're not supposed to be doing that. And if that's happening to you in your mediation by your attorney recommended mediator, we want to go back to the point that all mediation is voluntary. You are free to end this at any time, and that may be a good time to get out.
So if I become uncomfortable with the process,
Yeah.
I don't understand what they're doing, then I can stop it, I can get out of it.
Right.
Okay.
But let me go on the other side, because there are some folks that would really find that valuable. I don't know what happens in court. I don't know what to expect. I don't know what the law is. Please give me some advice. And they may intentionally pick a mediator or enjoy someone who's telling them, I know this judge. This is going to work. This isn't going to work. Still, even though you like that, by GODR standards, by the standards set by the state, we are not supposed to give advice, and we are not supposed to tell them what we think might happen in front of a judge.
Okay.
So beware. That happens. The other thing that attorneys will often expect the mediator to do is caucus all the time. The whole mediation takes place in private sessions in 2 different rooms. And what happens is the mediator will go back and forth between the 2 rooms, carrying the offers back and forth.
So the parties never come together.
They never see each other. They
Why
never
would they do
talk
that?
to each other. Why would the attorneys like that model?
Well, and what type of a conflict would dictate that type of?
I see it happen a lot in divorce mediation. The husband, the wife will come, and the attorney will the mediator, based on what the attorneys are expecting, will set them in 2 different rooms, and wife and husband will never talk to each other at all throughout the entire mediation
So the mediator is going back and forth.
with offers. Now think about that. You're telling me what you want. I want, every other weekend, right? And you go tell them that I want every other weekend.
With the kids.
With the kids.
Okay.
Right. Thank you. And then the mediator has to carry that and say, well, they were really wanting every other weekend with the kids. Would something get lost in the translation? Would something get lost in the...
Well, yeah, I can see the compassion, the emotion, and all of those things getting lost. I mean, the attorney is just going to be a carrier. They're not going to
Right.
really, they're not going to give the message maybe with the conviction that the party might have said it.
And how do I know that you actually gave them my offer the way I wanted it framed? I mean, I don't know what you're saying to them in the other room.
Well, you could have a conversation with the mediator before they left and ask the question, how are you going to present this?
Yes.
And the mediator is obligated to do it the way that they tell you they're going to do it.
Yes.
And in that process, if you tell them the way you want it presented, but you want them to withhold certain bits of information, like on the weekends when you have the kids with you, you're also going to have your new partner there, you might not want them to know that.
Yeah.
So you tell the mediator, but the mediator is obligated not to tell the other party.
Yeah, but think about it. I mean, let's really, if the attorney is trying to get a settlement and thinks that the way you're asking for this just really isn't the best way, why wouldn't the attorney mediator go back into the other room and frame it?
Well, the mediator, I would think, if they are feeling that way when you're talking with them,
Yeah.
then the mediator would deal with you around that.
Okay, they should.
To
They should.
have, yeah, to have
Yeah.
you to reframe what it is that you're requesting.
There's a great deal of controversy right now around this because there are many mediators that do not like the settlement conferencing model of separating the parties. You've got a mom and a dad who are going to be co-parenting for the rest of their life, and they can't figure out how to talk to each other. And automatically, the attorneys and the attorney mediator, they are assuming that these two can't talk to each other, and therefore we're just going to get a settlement as quickly as possible. Let's keep them apart. We wonder if part of that's because they're afraid of the emotion in the room or not being able to handle the emotion in the room. Or, to be fair, there is some risk that one party is going to say something to the other party that may damage the case, and the attorneys are there to protect that. Now, that's not too big of a deal because everything's supposed to be confidential in here. So beware, if you're getting this attorney mediator, you want to ask, will I get a chance to talk to the other party face to face? I heard the story, one guy, a husband, he lives out of town, came here for the mediation, right, court ordered, and was looking forward to an opportunity to sit down and talk some of this out with his soon-to-be ex-wife. Never had the chance. And his conclusion at the end of that, if that's what mediation is, I don't want to have anything to do with it. And that's just sad to do that.
But in all of this, the chances of reaching an agreement can be greatly enhanced through this process.
It can, even with the different styles.
Yeah.
We just want you to know that there are different styles. Some are going to serve you better than others. There's one more warning I want to give about attorneys/mediators. And that is, we're seeing more and more former judges retiring and then going into a mediator role. And I really want you to be aware, if you're self-selecting or your attorneys are recommending a former judge, to be very, very careful. And what I mean by careful is we want to keep reminding you that this is a voluntary process. You do not have to stay in that room if you don't want to. But judges have a terrible time being mediators. They have spent their entire career making decisions, telling people what to do. And when they sit in that mediator chair and they hear the evidence, the first thing they want to do is tell you what to do. And I've heard judges say, well, if I was on the bench, here's the way I would rule. That is against the standards of neutrality set by Georgia. And if that's happening to you, again, feel free. There's no coercion. This is a voluntary process. Get out.
So again, the decision needs to be your decision,
Your decision.
the party's decision. Okay, and we've talked about the decision-making process in the previous episodes. So I'm not going to go through all of that again.
Okay.
But the decisions that are made here, they can be empowering. And that's one of the big benefits about mediation,
Yeah.
is that you're part of the decision. Someone else, your example just now, someone else, a judge, isn't making that decision for you. So you want to make sure that, and again, just to recap a little bit, that this is an opportunity for you to get advice. If you need it, you can go get advice. And it's a voluntary process, so
There are so many advantages to mediation, and yet the public knows very little about what to look for and what to ask for. So yes, if they knew the power of this and what could be gained, I think more and more people would be choosing it.
okay. And they, if they want to know more about mediation, they can call the center
Please.
and they can get information. Be happy to talk with you about mediation
Yep.
and what are some of the things that you can do. And they can call us at, let's see, that number, 404-991-0072. So.
I guess that wraps it up for us.
That's the end of part 3, and hopefully we've been able to share some useful information with you.